So these rights are right to life, right to dignity of human person, right to personal liberty, right to fair hearing, right to private and family life, right to freedom of thought, conscience, and religion, right to freedom of expression and the press, right to peaceful assembly and association, right to freedom of movement, right to freedom from discrimination, right to acquire and own immovable property anywhere in Nigeria. Then the last one, which is the right against compulsory acquisition of property. All these rights, they are justiciable, as we will continue to see later. Justiciable in the sense that you can go to court and enforce them. For instance, Chapter 2 of the Constitution contains non-justiciable provisions. You cannot go to court to enforce them. Chapter 2 of the Constitution, directive principles, fundamental objective and directive principles of state policy. We cannot go to court and enforce them. But under Chapter 4, you can go to court and enforce, apply to the court to enforce any of those rights as stated under Chapter 4. Mr. Advisor, it's not moving at all. So sorry. Now, I need to quickly distinguish between fundamental rights and fundamental human rights. Fundamental rights, as earlier stated in those judicial authorities, they are the rights stated as stated under Chapter 4 of the Constitution. Fundamental human rights. Fundamental rights are within fundamental human rights, but fundamental human rights goes beyond those stated under Chapter 4 of the Constitution. Now, the purpose of this discourse today has to do with those fundamental rights as stated under Chapter 4 and not fundamental human rights. If you look at the interpretation section of the Fundamental Right Enforcement Procedure Rules, it gives the definition as I have stated it. It says fundamental human rights is different from fundamental rights. It says fundamental rights are those rights as stated under Chapter 4 of African Charter of Human and People's Rights, whereas fundamental human rights encompasses all other rights that have to do with humans. So under the interpretation section of Fundamental Rights and Fundamental Procedural Rules, the current one being 2009, we'll see that there. So as I've said, the thrust of the presentation will center on those rights as stated under Chapter 4 of the Constitution. Well, when it comes to proceedings that has to do with enforcement of fundamental rights, I think it only goes without saying that we'll need some basic materials that we should have at least have in our possession with a view to be well guided. Of course, one of it is the first one is the Constitution itself, the Fundamental Rights Enforcement Procedure Rule 2009. The Fundamental Rights Enforcement Procedure Rule 2009. We also need to have with us some of the laws or acts that has to do with the course of action from which a particular fundamental right may arise. When we have a clear knowledge of the law that has to do with that area of law, will assist us when we are trying to defend a fundamental rights application. Now, how is a fundamental rights action commenced? Now, a fundamental rights action is commenced by an originating process accepted by the court. We look at Order 2, Rule 2 of the FREP rules. I'm referring to FREP rules to mean the Fundamental Right Enforcement Procedure Rules 2009. Now, a court here is either a state or federal high court, or high court or the Federal Capital Territory. Of course, if you look at Order 1 of FREP rules, tells us, as we'll see later, there's no dichotomy between the Federal High Court and State High Court as far as the issue of fundamental rights application is concerned again. Gone are the days when we had gamut of arguments, Supreme Court, Court of Appeal, where issue as to when they say the subject matter is that of the state, parties are of the state, etc., etc. Therefore, you cannot commence where subject matter and parties and etc. are for within the purview of a particular state within the federation. Such action, notwithstanding as a fundamental right application, you cannot institute it at the Federal High Court. But today, it has been clearly stated by the Supreme Court that both courts, Federal High Court and State High Courts, have original jurisdiction as far as the issue of fundamental right application is concerned. Therefore, even the issue of Section 251, I was being engaged by our learned Director of Civil Litigation that whether the issue of Section 251 still applicable to fundamental right application again. The long and short of it, to the best of my knowledge, and based on authority that I know of, is that it is no longer applicable. What they are saying in essence is on those days, like a number of other authorities, even as you see, even in Tukur and government of Gongola State, and also of other authorities, Jim Jaja and COP of Cross River State, etc., where the issue of this issue of Section 251, which of course is usually our major defense when it comes to parental right application instituted at the Federal High Court. Today, we don't need to trouble ourselves. It has been clearly stated now. EFCC and REIL, I don't know the short form of that, EFCC and REIL. That authority, Supreme Court, 2022, thereabouts, citation is supplied here, clearly says that when the issue, in fact, it was Kekere, when the issue has to do with, it's under Chapter 4 of the Constitution, whether you file it at the State High Court or you file it at the Federal High Court, both courts have original jurisdiction to determine sale. So our arguments, all those other arguments, maybe some other causes of action, purely civil action. You know, this one is sui generis. It's only closer, parental right application is only closer to civil causes of action. But it's neither here nor there. That's why they say it's sui generis, it's generic in its nature. Therefore, you cannot, that argument is no longer acceptable to the court. That's what they have said. We can argue 251 in some other causes of action, as far as our own defense is concerned. Although, how I wish that with time, I believe strongly, this is just an aside, I believe strongly that this is an issue that really the state should take up. Anyhow, we want to look at it. Let's start, if you look at constitutionally speaking, in the spirit of nationhood, people that are aboriginal to a particular place can easily decide for themselves what they want. They can define their justice system. They can define how to run themselves. Now, exposing a state to the whims and caprices of the Federal High Court in the name of fundamental human rights application, to me, we look at it, and from even a number of judgments, a number of decisions and rulings that has emanated from Federal High Court, to me, I do not think that jurisprudence is well grounded. It's something I think the state really take up, even to the apex court, for the court to revisit it. As we'll see later, there's this authority. It's there in the presentation. Somebody had approached the Court of Appeals, LASMA, and I remember it now. Notwithstanding this decision of the Supreme Court, that the moment your course of action has to do with fundamental right application, that both state high courts and federal high courts have original jurisdiction to determine same. One of the justices of the Court of Appeals tried to distinguish that, and to that extent, went back to the old regime and held that if the course of action has to do with the states, agents of the states, subject matter of the states, then the state, the federal court lacks jurisdiction to entertain such suits. It's a 2022. I will get the citation for us later. But the challenge with that authority, as we speak today, is that if you cite that authority, even at the Federal High Court, almost every LASMA and almost every, if you cite that authority at the Federal High Court, what they will tell you, they will refer to other authorities where Supreme Court, they will say, well, this issue has clearly been determined by the Supreme Court, so we cannot be canvassing that. Well, maybe with time, we'll still look at, because if you look at the reasoning of that judge, my opinion, I think the judge was trying to make a point from what he said. And he tried his best to distinguish, even refer to EFCC and REINL in that judgment. Yes, he referred to it. He made reference to it in that judgment. But the challenge, I mean, it's an issue as stupid. There's no way we can really argue it. The issue is federal high court, state high court, which court has jurisdiction? They will tell you no, both of them. And that ends it. So that is done. Now, let's go straight to defenses. But before then, I was looking at commencement of it. I made reference to, in filing it, it is the originating process that is acceptable to the court that you use in commencing a parental right application. And what is how do you determine originating process that is acceptable to the court? Remember, we have said that the court, prep rules defines the court to mean either federal high court or state high court. Now, the originating process, how do you determine it? If you look at the same under prep rules, it says where there's an issue not addressed under the prep rules, recourse that can be made to the civil procedure rules of the court with a view to resolving that issue. In this wise, there is no, as far as the originating process of a court is concerned, prep rules did not state those originating processes. So they have recourse to the civil procedure rules in the case of the state high court, civil procedure rules of the state high court, and in the case of federal high court, civil procedure of federal high court. Theirs is 2009. In fact, that was state high court, I think 2009. And in those processes, any of the means of commencing action, 19, I'm sorry, 19, yes, thank you, sir. Any of the means of commencing action in those rules can be used to commence, to institute a fundamental rights application. So therefore, in case of state high court of state civil procedure rules shall apply, and for federal high court rules shall apply in determining what an originating process that is acceptable to the court. Now, fundamental rights are therefore usually commenced by one, originating summons, originating motion on notice, not motion on notice, notice of application, as we have it in Form B, Form number 1 in the schedule to the FREP rules, etc. So If any process that qualifies as an originating process as a general rule can be used to commence a fundamental rights application. Of course, you commence it by that originating process. You have what is called statement. Statement is the second process. The statement contains the name, description of the applicant, the reliefs you are seeking before the court, the grounds for the reliefs, and the affidavit in support of the application. That is what your statement should contain. It contains the name and description of the applicant, the relief sought, the grounds for the reliefs. Then you also have your affidavit in support of the application, and of course, your written address in support of your application. That's the commencement. Now, the affidavit, of course, shall be made by the applicant, for where the applicant is in custody, or it, for any reason, unable to swear to an affidavit, the affidavit shall be made by a person who has personal knowledge of the facts, or by a person who has been informed of the facts of the applicant. So let's go straight away to the defenses, which is the thrust of this presentation. Defenses to fundamental right application. Loosely speaking, we can look at it from two ways. One, your preliminary objection. The other way is to defend it on the merits, that is by filing counter affidavits and written address. The first one being both methods are known. Both methods are known or are provided for under the FREP rules. So that is why you can defend when we are served with the fundamental right application. At times, your preliminary objection may put the matter to rest permanently. At times, and on rare occasions, of course. Why? Our preliminary objection, of course, is on jurisdiction. At the end of the day, what ruling will the court make? Is to strike out the matter if your objection is successful. It will strike out the matter. If the matter is struck out, it's not on the merit. The applicant can still come back, go and put his house in order, and comes back. For example, if your objection is on ground of, say, was not commenced by an originating process known to that court, and the matter is struck out. Maybe it's the question of the applicant now going to pick an appropriate originating process and file suit before the court. But on some very few occasions, our preliminary objection may finally lay to rest a particular matter, depending on the maybe we'll come to that later because of paucity of time. Now, our usual grounds for a preliminary objection. I'm looking at the preliminary objection now. I'll go to the merit of the matter, very soon. The usual grounds are a ground that the main claim of the suit is not under Chapter 4 of the Constitution. A ground that the action is commenced by more than an applicant with different causes of action. A ground that no reasonable cause of action is disclosed against the respondent. A ground that the suit was not properly commenced, where proper parties are not before the court, where the suit is incompetent, where the suit is an abuse of court process. These are some of the grounds. It will appear that the grounds are ad infinitum, depending on how we look at it. You know that issue of jurisdiction is such a very wide gamut of a sphere of law, at least in our jurisdiction, that a lawyer with an eagle eye can at every point in time find something and he will raise it, and it may be successful. That is why they say, at least as a general rule, subject to the exceptions, you can raise issue of jurisdiction even for the first time before the Supreme Court. So at any time, anything can come up where we just make reference to just these few ones, especially ones that appear common with our own practice here. So a just brief explanation. One, that the main claim is not under chapter 4, it's a defense. You want to defense in the sense that, yes, you have been served with an application for fundamental right enforcement. But when you look at it, you find out that the main claim is not under chapter 4 of the Constitution. We have said it before. Any application under chapter 4, any fundamental right application that cannot be rooted under chapter 4 of the Constitution is susceptible to be struck out. It lacks competence, because the law is that before you can come to approach the court under fundamental right enforcement, you must be able to clearly, by your main claim that you are seeking in your relief, you must be able to show to the court that what I'm seeking has to do with fundamental rights as stated under chapter 4 of the Constitution. So now, to determine whether a matter, the main claim in a suit, is under chapter 4 or not is a little bit controversial, and if you like, at times it's a little bit technical, so to speak. Why? As far back as Nikitobi, as when he was Justice of Court of Appeal, he has said in IMF and Peter's side, people that it has become a fashion for people to approach the court under other courses of action that are not that should not be grounded on, that are not grounded under chapter 4 of the Constitution. Maybe that falls under pure common law, other pure civil actions. They bring it under fundamental rights with a view to achieving some ulterior motives. When I say ulterior, I mean, fundamental right appears is a simpler procedure. For example, you want to persuade the court, or in a way, you want to make the court tacitly to grant in your favor an interest in land. You can couch, some of them, they will couch their reliefs under the fundamental right, whatever, and come before the court. So he now said that it has become a fashion. Therefore, it becomes on the judge to critically look at the reliefs being sought. These have been the processes, other processes before the court, going to determine whether or not what is claiming before the court can easily be grounded under chapter 4 of the Constitution. And it is as far back as something 1997. And up to date, if you look at it, I stand to be corrected, it will appear that say on the average of suits that have been brought against us, Ministry of Justice, one way or another. And it cuts across all the departments, agencies. It will appear that it has to do with fundamental right. Why? Obvious reason. Number one, it is seemingly seen as a procedure that is a simple. It's not a matter of just filing your processes, motion, originating summons, put some whatever there, add your affidavit in support, do other whatever, and approach the court. As against, for example, a writ, where you file in court, you serve the other party raises preliminary objection. Your preliminary objection, I don't know whether that's still the position now, procedural position. We get to the to Supreme Court. Maybe before the ruling comes out on that one, it may take another maybe 7 years. Now come back. But for fundamental rights, whatever, that kind of thing cannot be found. Why? By the means of procedure, it's based on affidavit evidence. It is believed that you approach the court, it is simpler. Then you can easily find your way. Number two is that it will appear that counsel that are not within Ministry of Justice have this mindset that even police have done, or any other agents have done something, all you need to do is to just join the Lagos state government by whatever nomenclature you give to it. Join them. But by the time you are able to secure damages in your favor, to levy execution will be easier for you because government is involved. So that's why we have, I believe, that is why it will appear that the number of suits that are being brought against us via this fundamental right application is so enormous. So now, so therefore, we need to arm ourselves as much as possible when we are trying to defend fundamental right application. Now, grounding is the main by way of objection. We look at it critically. We go to what the law has said, how to determine it. I will make my whatever available. There is an authority, Emeka Okoroafo, where they are held that the way to determine the main claim in a fundamental right application is to go to the real issue in controversy. The real issue in controversy. In that case, what happened has to do with a particular church. Now, somebody approached the court under fundamental right application for said his right of fair hearing has been infringed upon. He now alleged that the issue of employment was there. Issue of his dismissal as an officer of that church was there. So the court, in that particular case, the court said the main issue in controversy here is the issue of your dismissal from that church as a member, I think a member of their board of trustees, and not issue of fundamental rights. Because when they are, the court further held in that case that the issue of fair hearing is only ancillary to your main claim. Your main claim has to do with your employment, which is not, and that court, the trial court, lacks jurisdiction to have entertained that suit. So the test there is to go to the real issue in controversy before you can. Of course, whether you like it or not, it's still a game of art. You get before some judges, you argue it, they say, no, I have jurisdiction. Well, you can only explore maybe appellate, whatever, or any other means. Look at it, but let us do our own part to say we go to look at that test. We go to the real issue in controversy to determine that if your main claim is not under Chapter 4, then your suit against us should be struck out. So that is that. Another ground, like we said, no reasonable cause of action is disclosed against us. I don't want to waste much time. Reasonable cause of action, triable issue. I mean, look at the affidavit in support to see whether what you are talking about, what have I done? There's nothing I've done, please leave me. That is that. If there's no triable issue against any respondent, then the matter should be struck out. Now, that is one. Another one. We also looked at yes, where the action is commenced by more than an applicant with different causes of action. Now, in this wise, I will refer us to this authority. But let me, okay. Yes, where the action is commenced by more than an applicant with different causes of action. You see, an applicant should have his own cause of action. If there is more than an applicant in a fundamental rights enforcement action, you have a particular cause of action, the second person has another cause of action. Both of you cannot maintain a fundamental rights action. That's a ground for us, ground of objection. And for this one, that's why we need to meet authority, Diamond Bank PLC and Opara and two others. Then that case, made reference to the case of incorporated trustees of digital rights lawyers initiatives and others, and NIMC. Now, the issue of where parties have different courses of action, again, is subject to, it's a subject of arguments here and there. But what the court have said here is that when the action of A can easily be distinguishable from that of B, then both of them cannot maintain the same fundamental, they cannot file the same parental rights application. It has to be separate. Now we should distinguish this from where they have a class action. You see, it's not impossible. For instance, it's not impossible that a group number of people may have the same course of action, though with some minor differences. That will be covered under chapter 2, under order 2, about the introductory aspect of the prep rules as to who a party to a fundamental right application should be. And we need us to, I will just briefly open that place and read it to our hearing, because I think this place is very key. Who now say the court shall encourage and welcome. I'm reading from the introductory aspect. Of course, they make reference to it when even in judicial process of this prep. You know, these prep rules, just time will not. These prep rules of 2009 happens to be a very radical change from the 1979 prep rules. Very, very radical. A number of innovations were introduced under it. One of the innovations, for example, statute of limitation. It's not a bar to a fundamental right. Hitherto, it used to be 1 year. The course of action must have arisen within a year. Hitherto, you need leave of court. You obtain leave of court before you can maintain fundamental right application, etc., etc. But the new 2009 rules came up and abrogated a number of all these rules. That's so that you have free access. It now define who said the court shall encourage and welcome public interest litigations in the human rights field, and no human rights case may be dismissed or struck out for want of local standard. In particular, human rights activists, advocates, or groups, as well as any non-governmental organizations, may institute human rights application on behalf of any potential applicant. In human rights litigation, the applicant may include any of the following. That is, the applicant is the person who institutes the action before the court. It may include any of the following. And it gives us 1, 2, 3, 4, 5, 6, 7 class of persons. It gives us 7 classes of persons who can institute a fundamental right application. 1, anyone acting in his own interest, anyone acting on behalf of another person, anyone acting as a member of or in the interest of a group or class of persons. This is exactly where I'm going. I'll come back to you. Let me read others. Anyone acting in the public interest, association acting in the interest of its members or other individuals or groups, the court shall, in a manner calculated to advance Nigerian democracy, human rights culture, pursue speedy and efficient enforcement and realization of human rights. Human rights shall be given priority, deserving, blah blah. So now let me go back to that point of emphasis. Anyone acting as a member of or in the interest of a group or class of persons. So there can be a class action. You pick 3 persons. They are the applicants. They sued on behalf of 50 others, 100 others. They can maintain a fundamental right action. However, it's without prejudice to the fact that their course of action is the same. There could be minor differences. That's understandable. Those minor differences cannot vitiate this provision. The requirement of law is that fundamentally, when there is all of you have the same course of action, then you can approve the fundamental right under the 1979 rules. You know, that issue of local standard was one of the major challenges of the bank. One of the major easy ways to try any fundamental right appeal there would say you lack local standard. And by the time you put it in, 8 out of 10 of such arguments, they have their way. But today it's no longer like that. So reading this side by side, these authorities, this particular provision reference was made into it by the Supreme Court, and a host of other arguments under it before the conclusion that come. You can, a group of persons can maintain an action. More than one person can maintain, provided their course of action is good. However, our own attack should be this. If on the merits we don't have a good case, but we think we now want to think outside the box to see whether we can have our way, we may have to go to what exactly is the course of action. Because you see, some of these things at times, it requires critical thinking. A course of action, you can never say that my own course of action and my brother's course of action are exactly the same, when no matter how minor, there is differences between us. You see, my reasoning about that is this. If I say course of action, it must happen, all the elements must be the same. That's what it means. For example, it's like saying, if you say you will stop us from doing something, what you are stopping us from doing, everybody, all the elements must have been the same. In the same way, if you say, this my brother and myself, our properties were, our right to own immovable properties is being infringed upon. He has his own property, I have mine. The size of his property is different from mine. Circumstances of purchase, if there's anything like that, we can never be the same. In fact, maybe it's the title that he has will ordinarily not be the same like mine. He may have his own allocation from federal government. I may have my own allocation from state government. He may have his own, maybe pre-land use act. I may have my own after land use act, etc., etc. By the time we put all those arguments, although naturally today, what are you talking? No. But you see, some of these things at times, by the time you begin to canvas them, one day, because you see, the justice of this really is, let's call it a spade a spade. There's no way two persons have come together to say we are asking for this. Even in your release, where you clearly say for party A, this is the relief I'm seeking. For party B, this is the relief I'm seeking. In your affidavit, what did you say? Would you have been saying that, okay, party A, these are the facts in support of party A, under the same affidavit? These are the facts in support of party B, under the same affidavit. There's no way, if you continue to look at it critically, there will always be differences that ordinarily their action can never be generically sustained. That's my point. So, but again, as it stands today, this kind of arguments will ordinarily not hold water. By the time you start, they say, where are you going? Forget that one. But some of these things that we are enjoying today were things that some people painstakingly went through, and we are enjoying them today. A number of innovations that we are enjoying under 2009 rules today, at least we were much, much younger. I know that time, they will say, local standard, look, just fire. This party lacks locals to sue, full stop. Throw it. In fact, that time was the moral was possible that time, and all that. Just throw it into the court, and the court will be issuing that one. They can issue it for the next 3 years. Praise the Lord. So, because of time, so we are through with the issue of course of action. Now, we have talked about the issue of commencement, course of action, and most of other grounds that we have looked at. let us quickly look at on the merit of the application itself. You want to defend the application on the merit. Time.
Sorry, Pastor, please go on. Just remind them. Those defense.
Oh, okay.
Just remind them. I think we are not having to.
Thank you, sir. So for defenses.
I'm taking.
Okay, under plenary objection. Oh, okay. Let me. Sir, yeah, plenary objection. Grounds under plenary objection. No, I said. Okay, okay, thank you, sir. So a ground that the main claim of the suit is not under chapter 4. Yes. That's one. Number 2, a ground that the action is commenced by more than an applicant with different causes of action. A ground that no reasonable cause of action is disclosed against the respondent. 4, that the suit was not properly commenced. That proper parties are not before the court. That the suit is incompetent. Then that the suit is an abuse of court process. So let's quickly go to the defense now on the merit. This defense that we have looked at is the defense by way of plenary objection. Though we also need to note something, like a defense by way of the plenary objection is not a defense of the merits. We all know that. Therefore, in the management of our case, I respectfully think that we can raise some objections. First strikes it out. The ban is coming back. So why don't you, I think the first thing first is to usually look at the merit of your case. It's only when you know that there's no way, as in no way, then you can now begin to explore your plenary objection. Plenary objection, in my opinion, I stand to be corrected. It's not supposed to be filed as a matter of course. Because there's some plenary objection that you just file it, you do all the arguments in this world, you bring all the arguments, you copy and paste and do everything. Okay, so I hold that this matter, the court lacks jurisdiction. As you are going out, they are serving you another thing in the same matter. So at times, then human resources, our paucity of hands, and all those of other things, we need to manage it appropriately. So that's just an aside. So defense on the merit now. The defense of the fundamental right application on the merit, of course, that has to be by way of refiling our counter affidavit in opposition to the suit, to the action. Our counter affidavit and our written address. Now, of course, let us not forget, when we are buying our counter affidavit, the rules of affidavit must be at the back of our minds. I will not want to waste our time on that one. We can write anything. At the end of the day, the paragraphs of your counter affidavit, they are subject to test by the court and even the other party. If it fails to conform with the rules of drafting a proper affidavit, one may be lucky, it may not be struck out. But if the matter goes on appeal, it may be the subject of appeal, and we know what the result will be. So it's always good to at times take the painstaking approach and ensure that we do the proper thing. So I will not want to waste our time on that one. But I also quickly want to, on that one, just refer to an authority. I've discussed this. I know Mr. Jibril is there. I've discussed this before. Some people did not agree with me in the way I saw it, but it is what I saw. It's not about Ogunsanya. It's what I saw.
and I think we need to look at it properly. Who deposits to our affidavit? It will appear that Court of Appeal said that our litigation clerk, even you as counsel, or cannot depose, they lack the competence to depose to an affidavit. Oga is supplying another authority now. Ojuku and Governor. Answer. It means that this rule has always been, if the reference is being made to you, well, not Ojuku and Governor is their main long case.
It's one of the issues.
Thank you, sir. However, 2022 Court of Appeal decision. Let me quickly go there. I deliberately quoted it again for our discussion. I know that Mr. Dudu will take me up when we leave this place, but I need to. Yes, thank you, ma. Thank you, ma. Thank you, ma. Who the song?
The beginning, sir.
Okay. Of the
name of the case. Is it
okay, yeah, okay. Yes, sir.
Yeah, something like
Mr.
that.
Dudu.
Okay, see the better one. And
Did he show you that? One more slide. No. Okay, Ibeto. They start from Ibeto. Yes, Ibeto. Now, this is the summary. The summary of what they are saying here is that apart from, you see, I should also say section 115 was contemplated here, was discussed. So it's not the issue of evidence. It's not the issue of the normal thing is that if you don't have the personal knowledge of the fact, your source of information, the time, the place, circumstance, you state all that. That's 115. That 115 was put in this authority, and they still came to a conclusion that apart from the person, only person who has personal knowledge of it can do it. So let me quickly read to save our time. Let me quickly read what was said there. Let me read what was said there. The rather forceful submission of, and it's not Obita. This thing is not Obita, it's Rascal. Yes, sir. The rather forceful submission of a lawyer counsel to the respondent to the fact that a deponent of an affidavit in a witness is a witness that can depose to facts that are within his personal knowledge or in information which it believes to be true, and same will be admitted in court as evidence and not treated as hearsay, provided that such deponent disclose the source of his or her information. Let's go to where I underline. Why it is correct that section 1154 of the Evidence Act permits a deponent to swear to facts derived from a third party in an affidavit, insofar as the source of his information is properly disclosed. Such depositions are of very little forensic utility, as they constitute hearsay evidence. Now, we went further. The fact that such information was given is all that there is to such information. But qualitatively, the truth of such information is a different thing entirely. It is hearsay evidence, and the truth which remains inadmissible. So, and my point is this: if we have a matter at the High Court today as we speak, and this is put in issue, the opponent cites this authority, and some, I'm sorry, with all due respect, some judges that are not as wild-minded as possible can easily be persuaded by this kind of argument. Ordinarily, really, I'm talking truly. Ordinarily, this kind of decision is need to be appealed, and there is really against the age-long principle of law. So now, let's just be armed by it. Fortunately, even me, really, what happened? There was a case like that. As usual, Gotley Street, I was in court. The guy cited it, persuaded the court, did everything. But fortunately, God did not look at. I think God just deliberately closed our eyes to that issue and judgment in our favor. However, I know that this is a potent whatever that ordinarily we should be prepared for to do something about it. So that is that for our defense. Now, we should now quickly go to, we have seen basic guiding section of Evidence Act. That one, we'll look at that one, conflict in affidavit. We know that fundamental right application is prosecuted by way of affidavit evidence. Now, the law is strikes that where there is conflict in an affidavit evidence, court resolves it via oral evidence. And the exceptions, there are exceptions. There are about 4 that we noted here. There are about 4 exceptions, but those ones, they are understandable. So save time. I want to go ahead. Let's just pick, there are few fundamental rights that are common in the processes that we are being served with in the MOG. So I look at 4 of them in specifics to deal with them. The first one is right to life. Are you going with dependence on merit? Yeah, this is part of dependence on merit. Now, what I'm saying is dependence on merit is done by way of counter affidavit written address. Now, we now go to the content of it now. Our defense, our facts. One, our counter affidavit, we all know that one. That needs no explanation. Counter affidavit must directly address all the facts, the positions in the applicant's affidavit. And we must not, of course, this is tried, we must not leave anything that is damaging without addressing it. We must contradict, thank you, sir. We must contradict them. And then if we go to some other deeper waters too, because we have, they say, like normally under pure civil, where they say general, there is this general traverse. I see that too in that temptation, and it's common to a number of general traverse in our counter affidavit. For example, the respondents objects, accepts as herein hereafter, the respondent objects to paragraph A of the and puts the applicants to the strictest proof thereof. So what have we said? Nothing. So we need to go further in critical cases. What I mean critical cases that really we need. There are dangerous cases. I look at them as dangerous cases. That this is a potential. If you have never entered PSC's office before, you may have to enter that office by you have never seen AG before, meaning to see AG. Well, if some of the case you don't handle it the way it should be handled. Now you can make that and think, oh, after all, after I counter, we file our account, we do everything. So think of something. By the time it's placed side by side, you find out you are really not. You can say, there's the word I'm trying to remember. I contradict or what there's the word I'm deny. Thank you, sir. I deny paragraph 3, 4, 5, 6. You deny, eh? Exactly, sir. So at times, if we are not careful, you can do your general denial and begin to say other things. We are not addressing those things that you have denied. If you say, for example, you got somebody is attacking, say your right to own immovable property. It's just that as an example, right to own immovable property. Meanwhile, that's your own title to the land was secured by way of certificate of occupancy. Now, the other party got his own, loosely speaking now, under native law and custom. If anything still exists under a law like that. Now, you in your own say, I deny what he's saying, that I took his land, because I deny paragraph 333 of what he said that I took his land, full stop. You never make reference to what rights you have, legal rights you have under that. So with that kind of disposition, we have to always have to put at the back of our minds that there has to be, see, authority has it. Affidavit must be capable of being believed. Otherwise, the test of veracity of it is zero. Court can just look at it and discountenance it. Mind you too, the strength, the success of a case is not on the weakness of the case of the respondent or the defendant. It's on the strength of the case of the applicant or the claimant, as the case may be. An applicant that comes must be, even where he's not filing anything, your own case, on the strength of your case, you must be able to prove it successfully. Therefore, when you two are defending, you must be able to defend in every sense of the word. So this kind of thing, of course, we know the circumstances in which we work. It's only occasionally that we want to think like this. The nature of how we go to do our work may not really permit for some of these very, very critical analysis of our case. Even judges themselves, at times, they don't even look at some of these things at times. But if you see some very critical ones, they will go into some of these things, they give you law. The federal court, when he was still there, Obiozo, the man will go into every academic, whatever, and everything, and before you know it, even you too, you'll be dumbfounded, because in all truth, he will give you law. Law that is, he will give you the law. He knows that he says nonsense. He give you the law. There's probably that law is not known to people, or it's not a common one. So at times when we are more critical about some of these things that we are doing, then it can be a very source of good help and defense for our cases. So specific defenses to right to life. Now, right to life, I mean, as is under section 33 of the Constitution, we've started authorities known to our law. The issue about right to life, I will Now, for right to life, the issue about it is this. How can we defend today? The state is joined. Somebody died somewhere. I'm not talking of murder, pure criminal. It's enforcement of rights under chapter 4, section 33. What are we supposed to do? What defenses are we likely to have under it? Somebody died somewhere, and we are joined as a respondent to the fundamental right application. Now, I said likely defenses to that is this. Is the AG aware of the alleged death through duplicate case file, which ought to be sent to his office by the police as required by section 74(1) of the ACJL? If the AG is aware, that is when his power is activated. If he's not aware, his power is not activated. Now, that's a defense that we are not aware. The law says that police ought to have brought that case file to his attention. So the one police has not brought it to his attention, somebody died somewhere, he's not aware. That's a defense. Although this is another issue before the court, but let's see what they will come back to say again. But we have extant law as we speak. Court of Appeal decisions says that the man should be brought to his knowledge that by way of duplicate case file. So he's not aware. Then number 2, has the legal advice been issued? If yes, it is conclusive and thus a defense. If legal advice has been issued in respect of it, you know, if you look at section 74 sub 2 of the ACJL, says that the content of the legal advice is conclusive. So if the Attorney General has issued legal advice to say nobody is responsible for the death of this person. So, and somebody has gone to the court to say, want to enforce his right to life. All he will say is that, come, I've had the file, I've looked at it, I don't have anything at my disposal to connect anybody to the death of that person. That's his defense, so he's free. Another defense that we can, now, of course, when he says that kind of thing, his power, remember, starting from state and Ilori, even the court cannot challenge his power. His procedural power under section 211. State and Ilori, and most of other authorities like that, Okereke, Onyu case, more recently, Barrister Olusegun Alalade, and another and State of Lagos, they repeated the same thing. When the moment he has exercised his power, even if he's joined as a party over there, all he needs to do, just put all these facts in our counter affidavits, annexing exhibits, legal advice, and most of other things to show that he has issued legal advice, and this is the basis of his conclusion, and there's nothing against it. Of course, more recently, one of our judges, Bogoro, followed this principle in the case of John Okechukwu, governor of Lagos State. Held the same, it has to do with the death of somebody. Legal advice was issued here. And we filed in court to say this is the position, and the court agreed that yes, the Attorney General has done all is expected to do under the law. He cannot be held liable under the other guy that the applicant sought like about was it 250 million or so, but the Attorney General was exonerated. That's a defense. So now another defense is if the death is a result of the execution of sentence of the court in respect of criminal offense. I mean that is right. Yeah. If he has been a judge, is convicted by court and is sentenced, I mean nobody can be held liable under fundamental right for that. If he dies as a result of the use of to such extent and such circumstances are permitted by law or such force as reasonably necessary. If the defense of any person from unlawful violence or for the defense of property with order to effect a lawful arrest or prevent the escape of the person lawfully, this is where our friends usually hide on. We know our friends.
Who are they?
Yes, ma'am. So the we usually hide under that. So those are likely defenses that we have if we are joined as a respondent in a fundamental rights enforcement suit in which right to life is the subject matter. Now, one by one. No, because of time, sir. No, just two that are remaining, not everything. I want also to quickly look at the another rights, which I think right to acquire and own immovable property. Of course, it's a right known to our law. If you look at it, the last two sections of under Chapter 4 touches and concern right, issue of right to own movable property, and right not to be disposed of your the property that you own. Now, both of them different, but they are So in the exercise of their rights, how do you? My thinking is this: when we are sued for anything that has to do with property, I think the first is that we should critically look at the title of the applicant. If we are able to raise any defense in the title of the applicant, we may have a good day in court. Somebody can come. See, people come to court with all sorts of sources of their alleged title to a particular piece of land or interest in land. Your deposition must show that your interest that you have in your land is recognized under the law. Federal Housing Authority and SOMNIA. It says before somebody can exercise a right over land or any piece of land, he must be able to show his legal rights over that land. Now, here I tend to think the legal rights here doesn't necessarily have to be title alone, as in ownership, interest alone, and I stand to be corrected. Other interests, maybe tenancy may be there, lease may be there, etc., etc. They may be there. My word, they may be there. It can come to, because if somebody in lawful possession, you cannot dispossess him without following due process. Therefore, if he sues under that whatever, but attacking his title, I think is key. And when we do that, I'm not in civil, but I know that Ijupu and Okumagba, you remember, sources of proving title. There are about 5, 7 of them. Now, 5. The moment This is my belief. And I start to be correct. The moment an applicant is unable to prove clearly one of them, then that case has fallen flat. It's dead on arrival. You are dead upon arrival. Because you can prove anything. For instance, we are all lawyers. People buy all manner of interest in land. Land that are acquired, committed, anything, they buy anything. Some people have money, don't worry, I'm a lawyer. They buy it. But when matter of litigation or legal process is activated, that is when the rightness or otherwise or whatever he has done becomes an issue. So you as the respondent, that is what we'll be looking at. When we are able to successfully prove that there's a defect in what is saying. So without that, it cannot be coming to court to say it's claiming right of ownership, that is right to own whether movable or immovable property is being infringed upon. It cannot, because it doesn't have legal interest or right over the land, the subject matter. And it's not to determine title. It's not the issue of title. It's not at this stage. You cannot use the process of fundamental human rights to determine who owns the land, who doesn't own the land. That is not correct. I stand to be corrected. You cannot use it to determine it. You go by way of it, depending on whatever. So if somebody also in his relief, he says a declaration that blah blah the land in blah 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 belongs to blah blah blah. You know where it's going. You raise objection, etc., etc. So that is another likely. Of course, I know where compensation has been fully done, we have evidence. And we have evidence.
We have evidence. We have evidence.
Yes, ma'am. Yes, ma'am. So that's one, not concocted. So, so at times also, we may not be a necessary party. As we see, Section 36 says, where a party is a necessary party to a suit and has not been joined at every process of the beginning, that is an infringement on the right to fair hearing of that party. So that law can be taken two ways. If I'm not joined, I'm supposed to be joined, my right is being infringed upon. If I am joined and I'm not supposed to be here, what am I doing here? So we can look at whichever way that it suits our defense to now put up something as regards that. So that is a few things I can look at under the last one being personal liberty. That one is very common. Thank God, some of this I've been saying is subject to scrutiny by the learned DPP. So personal liberty, we know the incidences where we have the usual thing under personal liberty, Section 35 of the Constitution. Somebody is being held somewhere, unlawfully detained, for instance. We are joined, say you are supposed to know, or you don't know, or you are deemed to know, whichever way. What are likely defenses to that one? I don't want to waste our time. When we look at the paper, our scenarios can be in three ways. For instance, where we have the file, that one is understanding, and we have done the needful on the file. We don't have a problem. And we do it done within time. Time is key. Section 264. Fortunately, yesterday, DPP argued very tenaciously before a judge. Now, come, this your Section 264 that you are talking. The other party was saying, Section 264 is unknown to law. They started from this our authority. Your and Johnson. It's unknown to law. Whereas EFCC and ABLA has said that Section 264 under our law is constitutional. So somebody is taken before that court for remand purposes is a constitutional procedure. So cannot say it's held there, it's a constitutional, blah, blah, blah. No. They now went for but the problem we are likely to have with that is if we fail to keep the time. This, at the first instance, the law is that we have 30 days. And we already, before we even receive file, like 30 days gone, we already, I should not say we are in trouble. So the issue of timeliness of any file is very key. So where we have the file, where we don't have the file, is key. We don't have the file, it's a defense, subject to some other whatever, it's a defense. And of course, where we have terribly bad cases, it can be, we might need to escalate with a view to looking at what can be done regarding that. That's the issue of personal liberty. I'm rounding up, SARS, man. Now, I need to also this is the last point I want to quickly point out. And that is on the issue of, I'm sorry. Okay, some basic things to note in our defense in fundamental right application. Number one, as against all other, virtually all other processes, means of commencement suit, this is what English will I use to describe this? Because upon service, we have 5 days. I start to be corrected. No serious legal whatever can be done within 5 days. If a concern in which you are placed, then we just want to deceive ourselves. And that is why far more than average, what you find in court is that people come for extension of time within which to do whatever. And of course, in our own case, where federal court is involved, we know every day of default is 1,000. And if anything happens, the thing now begin to can be 30,000, 100,000, 150,000, as the case may be. So we are put on our toes as far as this matter is concerned. 5 within this time. The other party 5 days. This one we get to court. My lord, we find yes, matter for hearing. I set it down for hearing tomorrow. Come. We don't have. There's no breathing space at all. It's not the timeliness in it is not to our convenience at all. However, there's always solution to every problem. So we should also always put that in mind. Now, except for a few judges, most judges want to dispose of fundamental rights for obvious reasons. Prep rules, innovations, and of course their own rules within them. Say it's fundamental rights, human rights, and also the sentiments attached to it. If you ask me, there are some unwarranted sentiments attached to the idea of fundamental rights, whatever. They killed that man. They killed him. And you get to court, you are the one to come in to defend the person who killed that man. You are even everybody will looking at you as, oh, you speak very wicked. In the same way, you get to court. What happened? I can see. They killed him. Yes, what do you have to say? What do you have to say? So, so that is the kind of thing. As against, I stand to be corrected. Give it to be read. Should be upon service of say on claim by the read and other upon me. I have 42 days, Abi. 42 days. You can serve me. I go and sleep and be doing my research as to how I'm going to nail you. For 5 days, especially for things that are very, very novel. I want to research. Meanwhile, do I have other things that you are? I'm just trying to address issue that is reality amongst us. So when decisions are being made on some of these cases, by way of assignments, by way of even in our files, things that touches and concern fundamental rights, the issue super expediency should be uncertain. In my opinion, there should be a special creation. What I mean by a special creation is, I'm not saying we create a unit. There should be a kind of special understanding as far as when they see it, even from top, when we are served with it, even from top, come down quickly, do whatever we have to do. Let us get. Meanwhile, when we are rushing, no doubt about it. I've tried it over the years. There is it appears as a law of nature. When you rush your thinking too. You rush your conclusions. And that is why at times you get to court where you want to write plaintiff, you write claimant. When you want to write deponent, you write deposition. And say, Mr. Lee, have you looked at your paragraph? That, yes, my lord, you've seen it all. I am actually. So, but we can whittle some of these things down by the way we manage ourselves, even within. For example, fortunately, our DPP has been of very immense assistance to that. When we cry to him to say, these are ABC things that we need as far as this thing is concerned, quickly ensure that. Because, and of course, me, I don't hide. When there's a potential danger, I make it known. I'm not God. potential danger, potential danger, damages is coming, no. I mean, what can we do? Because you see, anyway, so just an aside. So then 3, note that some of our cases are almost irreparably bad. I've said that one. We need to escalate, look at what can be done about that. So now, lastly, in Jaja and COP River State, we can note it's in one of the, in that case, court clearly held that, of course, right principle of law, relief not sought can never be granted. In that same case, court went ahead to say, yes, the trial court was wrong to have said not to have awarded damages against the respondents. That the moment issue fundamental right to personal liberty alone is clearly seen to have been infringed upon, that the court ought to award damages, notwithstanding that it did not claim it. Me, I have a concern, very serious concern without I keep it. Fortunately, it will appear it's either that many of our judges do not know, or there's something I'm not getting right about that law. I've quoted it there. Of course, the law is that whatever is not claimed before the court is not Father Christmas. But when in case of personal liberty, see, the moment is right to personal liberty has been infringed upon, whether or not the applicant prays for damages, the applicant is entitled to damages against the respondent. Clearly written in that authority. That's another food for thought. We need to be careful. And I know some of these radical judges that we know, they have this authority. Like today, usually, like in the past, as I said, in the past 4 years, usually when we have taken, for example, the defendant to court, we are filed. No matter anything, they look for a way around it. We are free, we go. But these days, courts are beginning to award damages against us for matter that is pending before his learned brother. Where we have, I can see that yes, sir. A matter that is pending before his learned brother, court of coordinate jurisdiction awards damages against us to say his right has been infringed upon. Of course, he will naturally say, it's without prejudice to that charge that you have filed, go and proceed it. But the right here has been infringed upon. Justice Ijelu, with all due respect, still repeated the same thing maybe like 2 months ago. Not that you are what he said it in open court. The mere fact that they have filed, and I'm sure, thank God that matter were able to escape it. It's just divine intervention. Otherwise, I'm sure if we were to go through that matter to the end, we'll award damages. And such judges will be relying on authorities like this. And that is why we also need to up our games when it comes to this kind of thing. So by way of conclusion, I say from the above and in line with the reasoning of Nikitobi in Peter's side and IMB, where he held that it has become a fashion or style for parties to push or force the provision of chapter 4 into most claims, which cannot in law be accommodated by the chapter. We see this every day. In view of that fact, we also need to up our game, do more internal arrangements with a view to ensuring that, because it's potential, I see this in every day, that some of these matters, whether we like it or not, at the end of the day, it may take some time. The matter is still in court 1 year, but we know that as far as the law is concerned, if that court just failed to see that, it will award damages against us. So, but generally, it's because it will appear that we have not really internalized the mechanism towards ensuring that the propensity for them to be having causes of action against us is highly rooted down. This is where I will stop this presentation. Thank you so much.
Thank you. Mr. Lamide, I just want to briefly address in relation to some of these issues that Mr. Ogunsanya raised. Some of the defense are also in the Constitution, like rights to removable property, section 44(2) K said if your property is needed for purpose of investigation, it can be interfered with. So all those defenses as well. So when you are reacting to your affidavit and all those, you need to also look in there. And the case that Mr. Ogunsanya was referring to, the judge was also smart. He just said, I agree with your position, DPP of section 264. But is there anything in section 264 that give police to hold somebody for more than 1 month? She put me in a corner, very smart judge. I said, in as far as I'm concerned, I don't think that is the right interpretation. And I said, also, sir, what I want you to know is that these issues, this entitlement are not absolute. And I'll judge her by saying the issue of detention, I'm not aware of it. So I cannot go into it because once I said the police have done that, I'm doing the service, I'm joining the issue with them. So anytime they are bringing, once it doesn't consult, don't get involved. Because once you get involved in that controversy, when they bring the judgment, they will put your own position. So now if she turns around and find the police, she will never involve me in that because I said the issue of detention, that's not why I'm here. I'm here because of section 264. That what we've done is proper. We filed information with issue early. That's why, and we even applied to be joined because they didn't join us. Somebody that will issue legal advice, we are prosecuting. We are suing the police and prison authority for breach of the covenant that you should be released. So we made it to remove some of the release that affects us. I think that was I should mention that.
Thank you very much.
Yes.
Sorry, I think just to add briefly to what he said, I think the cross and the base of all of this, he said something about the weight of your affidavit evidence, the fundamental human rights enforcement features. So if you are before the court, your affidavit is not in conformity with the rules of the evidence. I think we are not going to have a case. Because of time, I think we were unable to go into when your affidavit is there, when you complete agreement, so that we are so that you are in the position where most of the parts will be checked with that upon and proper. So your affidavit evidence must be defined as argument. Thank you. Both online. So let me send something. It's online.
All right, so we're going to allow those online to keep yes. But I just thought it was important for us to once again appreciate Mr. Very brilliant presentation. We are all proud of you. He's our own so yeah. And as he was making his presentation, I was thinking, well, there are two types of brilliant lawyers. There are brilliant lawyers who know the law, and there are brilliant lawyers in whom the law resides. I think the law really resides in this country. As was bringing out all the nice. Okay, so we're going to take questions. We're going to take questions from the physical audience, and we're also going to extend it to our virtual audience. If you have questions, you could. I will come to you, sir. I'll come to you, sir. I mean, this is academic, but Mr. Ogunsanya opened by drawing a distinction between fundamental rights and fundamental human rights. Yes, I know fundamental human rights, and I know directive principles of state policy. So I wanted to know where we got that description of fundamental rights from. And do you want to note the question, sir?
Yes.
Now, he was talking about paragraph by paragraph denial of affidavits. Now, one thing that I do, I mean, my style is that at times when you read affidavit, you see that this person is just talking nonsense. And I try to push my position forward, first and foremost, by first telling my story. Then after that, I can now lump his own paragraphs together and respond. So I wanted to ask if I could get my fingers burnt, concerning, well,
in Jesus' name, following your footsteps. I haven't, my fingers haven't been burnt, but I want to know if that is the right way to go. Now,
What's the right, sorry, I didn't laugh.
no, I talked about when I'm responding to an affidavit in support. So in my counter, if I see that what the applicant has brought to court, does the facts don't really make much sense, but I want to respond. And I know that he has disclosed some reasonable course of action against the state, even though he has not said it in a manner that would help me to be able to put my case forward the best way I can. So I try to tell my story first. And then after that, I will now start lumping these paragraphs together. In response to paragraph 1, 2, 3, 4, 5, and 6, this is what I have to say. But before doing that, I would have first put my own story forward. So I wanted to ask if that was appropriate. Now, talking about defenses within 5 days, I know that you lamented a lot about PS has decided to adopt the style of Jesus, sitting amongst the you're welcome. So I was saying that Mr. Busa, you can maintain your PS as thank you, ma. All right. So I was saying that defenses within 5 days. I know that you have lamented about how difficult it is for us as state council, particularly, to file our defenses within 5 days. Now, are there instances where one is able to, particularly when you look at civil matters for DPP? You talked about a right to life when you were giving an example, and you said that in that instance, you may be able to file your defense because the duplicate file, that's within your control. So you're able to see whether there is a duplicate file in the DPP's office. So you're able to know whether that matter has been brought before has been brought to the knowledge of the Attorney General. But in civil litigation, you are dealing with aliens, people who, I mean, you have to be pursuing them to be able to get your appropriate defense. So I don't know if you have anything to share as to how one could address this kind of issues. I would stop here for now and take other questions. Do you want to respond to this once now? Okay. And to our virtual audience, if you have questions, you can put them in the chat box and we'll read them out later. Thank you.
Yes, very quick. Fundamental right and the fundamental right.
You can sit, sir.
The interpretation section of
You can sit there.
Interpretation section of the referee. Clearly states that the difference between the fundamental rights and the fundamental human rights. Everything on that chapter 4 is fundamental right. While fundamental human rights. Fundamental human rights only includes fundamental rights. That's what I will read it now. It says fundamental right means any of the rights provided for in chapter 4 of the Constitution. Now, human rights includes fundamental rights. So there's a difference. So that's why, well, why this is just for a background, whatever. It's not a key anything to whatever we are saying. The material thing that we have said the other time that we must ensure that an action, the parental right application, can easily be grounded under chapter 4 because the point can be positioned. The second question is that issue of lumping, well, how come our seniors are here, the NGPS and our seniors are here. I think in each case ought to be taken on its merit and its circumstance before you can know your approach to the proper defense. But I know generally there are bureaucratic issues, even within DPP, anywhere. Not necessary that you can identify that this person caused it, but you don't find that there's a problem. You find
or you can't find a file, get to the registry can just not find it. No living it. Yes, the system can say it is Mr. Lagbaja, but you cannot see the file physically, and that is only. The same agencies and all that. Now, what I think is that first thing first, to every case, there's always a background information and our defense. To every case, we can always find out who that is for. I forgot to refer to that. We can still leave of course to find other affidavits later. That's the motion on notice to see people. When parties have joined it, I forgot that. When parties have joined it, he has filed his parental rights application, he has filed your cross, he has filed his further response, and matter set from there. Nobody can file any other process. Then the argument that is also that otherwise no process, there will be no end to filing of process. But with think of court, we can always have our way. All we need to do is to justify whatever further information that we may need. That's what we can do. And that advantage in that is also, especially at the federal airport, this issue of people. If we have filed general defense, which of course, not damaging general defense, there are defense that we are sure of that no matter anything, the state will never say, I did not allocate a particular portion of land to so and so person. If you can have an idea that this is the land, for example, he has attached a sea of food, you could go to that to confirm that this you can have a general defense to that. If, for example, it's land with it's other property, general defense to you, then later you can now do your and at least the legal fees is up, then you can do further whatever on that. Then the last one, on the issue of filing of first of all addressing and stating your own case before it, in my opinion, and I think that's the law. We are referred to authorities in our right to. That is the case. For fundamental rights authority, I've seen the authorities. The truth of it is on the applicant, as with any other action. The truth of it, everything is on me. Now, where you are stating your own your own paragraph, you are saying, remember that is your own case. I think what should start should be your own reaction to what he has said. Then you can now link your reaction to what he has said, you now speak your own story. Because judges are human beings. I believe that at times some of people they are reading about the 4, 7, 8 paragraphs is not interesting to you. This writing is something deep. What is he saying? Especially with all due respect, some of these northern, I'm sorry to say that. Northern judges, I say without any. They will just look at it, they have not said anything before you know they are giving judgment to judges. That is the truth. We are now going to appeal to the something later. Even some of our Western judges, what happened recently like that? Somebody was a magistrate in Lagos State. The appeal is on appeal now. We need to be a magistrate and the judge at the federal high court. Don't read. You don't read it. That's the truth of the matter. What we further file, which is even the top, the truth of it, you don't read it. So that's my thinking. The last one being that the 5 days thing, I think I've answered that one. Thank you. Thank you. Thank you.
Thank you. Okay, we try to record. Oh, yes, it is.
I think we need a little bit of fiction. General. I need to know the time what to do by general. So we do just the full party now and all the parts. So we talked about affidavits. I think we will take somebody will be issue of what it must contain. Yes, I think about that. It's important because we also have years.
Yes, I'm of general defense. What I mean by general defense is, let's come home now. Everybody in each department will have an idea, and also the agency and MDAs that we relate with. We have an idea of what goes on. Somebody in civil has dealt with this of environment, has dealt with this of on cases that are handled. You are putting safety years, 2 years. The same thing in any other department. Ordinarily, when any matter comes, there's usual way to know that this thing cannot go the way they are talking about. We know what the situation should really be. Let me be more specific. Okay, somebody takes us to court, like I've said, takes us to court for prospect of parental rights for life of a deceased person. Now, when we look at it, and we don't think, okay, we cannot find the file, we cannot do anything. But we can see clearly that that action was brought by no, I want to look at the hour of the no. You look at it and say, well, we know about this from our own perspective. The positions in these are contradicted. We now say that to deny A, B, C, D. Of course, after the introductory paragraphs, we deny we deny the fact that the AG or whatever government agency is involved or is connected to the alleged treatment of right to life, enforcement of right to life. We deny that. We say that we say it is not, for example, we say it is not, though that will not really be a fact, but at times I must say the truth, some of these things fails true. It is not common. It is within the practice of the Attorney General, for example, to ensure that the right of life of every citizen within Lagos State is fully protected. That is why, for example, he has done A, B, C. He will make reference to certain things that we know of in protecting and such. By the time you fight think and take, by the time you begin to write all those things, you may have come on with a 15 paragraph to counter affidavit. At least what we don't say, you are not reading something, but you know what you have to work on is to ensure that you don't get the full information, the valid information. So that is my thinking. When it's a land matter, everybody knows. Okay, somebody files an action, says, by right to own immovable property, movable or immovable is being infringed upon. And look at it, he said that one of the means of proving title to land has not been clearly stated in fact in support. You deny that one. You say there is. I can see clearly that there is no right. The applicant has no legal interest in the subject matter of the suit. That's a paragraph. That has no legal right to the land in issue. You can go the land in issue. I know as a fact that the land in issue is covered by so and so as a global COO. Just write that one because later we have other facts to address what you are doing. So of course, another this more contain external standard. Legal argument, objections, etc. And that's the dangerous one. It's also a ground. Thank you, my NTPS, to remind us. It's also a ground for us to attack the positions in the academic support of the because usually the temptation that you will infringe and that you will fall short of the expectation of that position very, very high. It takes high practice over there that will not, or if you give, as I'm saying, I'm too sure about it. If we not go to our department and bring 10 affidavits, 10 of each, and put it on this thing, all the paragraphs 1,000, by the time we need to check
as to the test, because the courts have come on with tests for determining this over the years. Most of them, and it's not us alone, it's a general thing. So, but when you know that your defense is also one of them, when you know that your defense is, you don't even have, you don't have information. You can, one of your objections, this, and this thing offense, this section 1, you now take the law. That is, and so for some of you judges who doesn't even want the work to go on, we know that I agree with confidence to this one. I don't know what about everything. I think those paragraphs talk about that. That may be the end of the day. The man may look at that. What am I doing here? And I go back to drawing board. So that's a thank you for MCA. That's one very key. If you want to thank you so much.
All right, you control the mind. Okay, before I come to Mr. Remoda, we have two questions there. One says, do we need leave of course to file for that outside affidavits? And the other one says, is an artificial person capable of enforcing fundamental rights? Also, does the distinction between fundamental rights and fundamental human rights have any connection with the fundamental rights enforceable by a natural person, and that's by an artificial person? It's on the screen, just in case you want.
Okay, no, thank you. So the first question is an artificial person capable of enforcing fundamental rights?
No, because we need legal.
No, we did people. The moment this is how it goes, the applicant files and serves the respondent. The respondent has 5 days to file his counter and written address. What the law says that he files his written address and it needs to files his counter 5 days. The applicant has 5 days to file his reply and further affidavit. The moment, I think at that point, that's why people will say they have joined issue. You have joined issue. No party is allowed to file any further process at that point. However, with the leave of court, you can. You rely here. This is also very important. The leave of court that you just time is also in the paper. When you are seeking leave of court to file by whatever nomenclature you give it, further counter further or any whatever you want, anybody wants, even the applicants have been saying the same thing. You need to see how you do how do you rely on, or what rules are you to rely on for that? Now you come to court by way of motion of notice. It leads to file your prayer. Your first prayer will be, I pray for leave to file further counter affidavit, and this is where I usually count. Needs to file, serve, and rely on blah blah further counter affidavit. So then any other prayer. So now, where we need to be careful is that we need to show clearly why those facts were not brought before the court within time or at the right time, and that can always be done. Then the rule that you rely on, we said it the other time. That rule does not make provision for a number of things. But it says where any issue arises that no provision or adequate provision is made under pressure, you have recourse to the civil procedure rules of the court. The court is either federal high court or state high court. So the civil procedure rules of we will open the civil procedure rules of that to look at it. In the civil procedure rules of both courts, they make provision for filing affidavit out of, as in further affidavit that further affidavit of some sort. What I mean by that is that they know that you have filed affidavit at the normal time, but you now need to file a further affidavit or by whatever name you call it, with a view to bring all the facts before the court. Those rules allow for the same where provisions are made for a particular party to file affidavit within a particular time. Failure to file it within that period shall stop that person from filing it, except with the leave of court. And those I refer to those rules in the right of the idea. We rely on those provisions under the civil procedure rules, and of course under the inherent jurisdiction of the court. Of course, you can always add our usual section 36 of the Constitution. You add everything together. Now begin the argument. Leave of court. The leave of court is it's an equitable review. when we are going to court, say court. So normally, I ought to have done this, but I did not do it. But I'm here to do it. And with my law, if I'm if my law fails to give me order to do this will happen. And it's not in the interest of justice of the matter. No judge will listen to that. If concrete has facts anyway, concrete facts, so not just fixability. We can say anything. It's very easy. We are fine. It can be so. But when we get to point, it's not so. That is where we know whether we truly are fine or we are not fine. So that is it's there in the light of and make it available. I will expect critics too on this to improving ourselves. Thank you. Then the second question, I'm taking too much time. I'm sorry. It's to the best of my knowledge, an artificial person cannot fight for the other woman to the best of my knowledge. Cannot. It's only a natural person that can. I know that few, when it comes to that, many people say, for example, it used to be, they say cannot fight another right on behalf of the dead. Other 39 rules, prep rules, you cannot. But that is one of the innovations there. The court has come clearly to say, if you say the person cannot fight, what is the essence of your 33? People cannot fight, but they can fight on behalf of the dead. So there are few exceptions in terms of the juristic nature of an applicant, but that of artificial person, to the best of my knowledge, no, it's not possible.
But what happens where it involves right to property and the property is owned by an artificial person?
So a company is run Lioness engineering or something. The company is run by officers and directors. There's always the principle of lifting the bill. A company is not in the nomenclature. It's a company of human being essentially. I understand what that really means, but in terms of bringing an action before, why, for example, usually when a matter is filed in court, so and so company limited, you always see the managing director following you. Managing director will follow you. So you got a company, in my opinion, I raise an objection. Can a company talk?
And not through his officers.
Yes. So the officer is able to come forward.
My understanding of lifting the bill is that it's done in certain circumstances, like where there is fraud. I don't think it's intended.
Say, I do that for me.
All time.
Something that is in vacuum. Yeah,
The issue of lifting the bill, in my opinion, would apply in those kind of limited circumstances. Let's draw a line of distinction between the limited liability company and a sole proprietorship. Of course, in sole proprietorship, we know that that person is a company.
Yes.
So, and that person is answerable for anything that comes up.
Yes.
But in the limited liability company, those people who own the company are different entities from the company. In fact, the properties that we're talking about do not belong to the person.
Yes.
Those properties belong to the company.
Yes.
So except in situations where certain permissible situations under AMA, I don't know if bills can be lifted.
Okay. Thank you for the loyalty, whatever. All I'm saying, I've stated one of those that to remember the company operates by men and by officers and of the company. Let's leave people to do. It doesn't exist. You know, Mr. Ogunsanya, they will assist me without authority. A company operates through officers and directors of the company.
Yes.
So let's leave the issue of lifting today. I only do that.
I think it's all time goal is the all time come true, yeah.
My thinking, something to see authority that says, I've not seen it. I've never seen it before.
Okay. So
That's why when we bring charges in criminal proceeding, we bring the name of the company and also the directors in their individual. So if they escape as the company, they will not escape as an individual.
okay, so this is the learn series. So I would like to throw the challenge out. When next we meet, please, if anybody has any authority that says something to the contrary, that says that you have something to do.
Okay, people and other and KFC it was said that which call?
Yeah.
That a government can enforce crimes.
Yeah.
And it says that although there was a case cited of only to Niger, the great Benue state government, that was 2005. But in that case, that it was said that the public cannot enforce it. But in this case, the case of the people and everything was said that the public can enforce.
What's the citation?
What is the citation? All those people and another, the case EFCC and others. 2014. LPEX 24079.
Okay.
Thank you.
Thank you.
And it's assuming a limited company, a limited active company is involved in the case where it was denied, it has the right to sue for which of its fundamental rights to fair hearing. Thank you, God bless you, sir.
Thank you very much. Issue resolved. Okay, so please have the others.
Mr. Thank you for the scholarly presentation. I have it's perfect. I have several questions, and I know it's like the time was not allowing me to ask my question. There are some very controversial questions I have, but I will drop them for some other time. I will just go straight to very few directions for the interest of everybody. How can you institute an action to protect the right to life? I think an action on behalf of the I just said on behalf of the patient. The preference allows that. So how do we do somehow? If guy is this, you are now coming up. It's not a class I should be not I am coming up to. So that is one of them. The others let's see for another day.
So, thank you, sir. Thank you, sir. So we take an action for the enforcement of right to life of the disease. And to compose is the same procedure of the the person must, of course, be one of the dependents or relations of the disease. Of course, we will write the name of the disease, we will write his own name, Africa, for suing on behalf of that. So in his ability to support, he will state his relationship with the disease person. And that, in fact, thank you, sir.
And so maybe somebody who has a network organization could be able who are representative of the exit of the
thank you. But to the best of my knowledge, and in fact, that's why I'm even going to they said in Chinese is on page 19 of the Chinese Akubuko and another, the Police Service Commission and others. One of the issues for determination of whether the concern right to life of the dead person can be enforced by the defendants. And in resolving it, courts now went and held that it can. Now, the material thing is that you show your relationship with the disease. And then in the issue of whether the person is an administrator or whatever to the disease person, to the extent of the disease person, well, that is, they don't look at that there. The material thing, of course, I believe that, not believe, you show your connection, your relationship with the disease person. Of course, by way of, you have some other, for example, you may have to bring your death certificate, you may have to bring some other document, maybe when the person is buried, you are this, you are that, photographs, this one, that one, just to show the relation between that person and this person. So when that is done, sir, that person has clearly shown that the service is local to have the tenants. Thank you, sir.
I'll just ask this last one and then. How do we start the subsequent application after filing counter in the rush? And later have the main.
That's very good. Yes, well, we have several tagged it as further and not even once have we received any objection. Further counter them.
Thank you very much. Bro, please make it very brief.
The bill of Sudan.
I don't know that to take but you wear research paper quality however, on the issue of Pollard was presented, I read some points, particularly on the issue of having counsel to propose.
Where is the authority?
The Supreme Court authority, Marigold representatives.
Now you can talk.
What year?
2020. The Supreme Court authority. And what they are saying in that case is that generally as lawyers, without evidence act or with evidence act, we are not permitted to depose to a counter affidavit that we are retained in that case for, except that case is a non-contentious matter. That is the rule.
Yeah.
So what?
But as the council is MOI and they are together, can you depose from them?
Yes. So what that rule is saying is that once you are retained in a case for pecuniary profit, you cannot wear two hats. You cannot wear the hat of the counsel and wear the hat of a witness. So our professional rules of professional conduct rule 20/6, she's telling us that once you know that from the pleadings or from the fact of that case, this is going to be conducted, withdraw your representation immediately. On that point, when you do that, your counter affidavit cannot be invalid because you are no longer a counsel. Furthermore, sir, on the issue of on that same on the issue of let's just read on the issue of fundamental human rights, I also believe that our laws have also developed up to the points of saying that the fundamental human rights itself subsumes the chapter 4. Because if you look at the case of Olafisoye and FRM, what the Supreme Court says in that case is that even if your rights or whatever complaints you have, even if it's in chapter 2, that we all usually say that it's not just even if you can remove it, that's the provision in section. That's the provision in Olafisoye.
The decision was not interpreting the evidence act after that. The Marigold decision that
yes, it's on evidence.
was it interpreting section 115?
It was interpreting evidence of counsel. Evidence of counsel deposing to affidavit on behalf of party.
You mentioned the evidence act.
No, what it referred to is the rules of professional conduct. That is debate for lawyers. If you want to remove the argument with evidence act, to start with the evidence act is not to mention lawyers. So on the footing of evidence act, it's also the part of party decision.
Okay, we have a look at it.
So that decision that is a very controversial one.
So that famous system.
Yeah, about contention, the distinction between contentious matter and not. When it's contentious,
Because cannot get.
So the typical case we're talking about here now is the case, hello? Hello? So the typical case we're talking about here now is a case where the same counsel who
are playing the case? Who are playing?
let's say the person who signed the written agreement, right, is that's what we're talking about. So it doesn't matter. Both of us, hold on, exactly. That's what I want to point out.
For that to say that even if you are in the chamber, a counsel in that chamber cannot depose to it. Because you should know, because as a matter of fact,
In a contentious matter,
yes.
can I do it a fundamental human right?
Fundamental marriage.
So one of the arguments we made, right, for the court to convert from affidavit to read, to originate, thank you, originate supposed to read, is that it's contentious. So you say when it's contentious, it means you will have to call evidence. So you ask the court to decline jurisdiction, and that was why I asked that question. So if it's fundamental human right, then it means that we are taking it out of contentious matter. Do you agree? No, you don't. All right. Okay. Okay. So very, very sadly, this is where we're going to be ending the last series for today. A lot of issues keep coming up, and we'll come back again to discuss this.
Now we can address those other. There are several questions.
Okay. Okay. So, Mr. Lawa was just bringing to my attention now that when the presentation was being made, the presenter mentioned that by virtue of the prep rule, you can bring a fundamental human rights application by any means. Was that for the only ordinary process, but by to that point, was that the law school standard is that it has to be by ordinary motion. I don't understand. It says that for the purpose of those as a law school, so that they will not go and say the authority is the Ministry of Justice. So, but the prep rules actually says that you can come by any ordinary process.
But in standard practice, we come by rotation.
Okay. So another thing for the law school students is that the National Industrial Court can hear fundamental human rights application. All right, so this is where we're going to be hearing the lesson for next one. May I implore the law school students to please allow counsel who ask them. Please remain seated for directors and other counsel to file out. Thank you very much. We'll see you again next time. Fine.